Thank you very much, Priscilla. Our next speaker is Peter Apple. He is Alex W. Smith Professor of Law at the University of Georgia in Athens in the US. And Peter's talk has the intriguing title, Sustainable Commerce, Private Ordering Systems Enable Multinational Businesses to Enhance Corporate Profitability, Minimize Environmental Impacts, and Control Corporate Risk. It sounds like Peter has found a panacea here. Is Peter here? Is he available? It would be fascinating to hear this talk. No? Anyone seen Peter today? Okay, well, looking forward to see his work then on the website. Then we move on to our third speaker, which is Marcia Narine. She is professor at the St. Thomas University School of Law, and Marcia's topic is climate change and company law in the United States, using procurement, pay, and policy changes to influence corporate behavior.
So I am possibly the last speaker. I'll keep it short so we can commence to questions or drinking, whichever you prefer. And to give you a little bit of context about my remarks, before joining academia 2 years ago, I spent about 21 years as an outside lawyer and then as an in-house lawyer for a company that managed transportation systems and supply chains around the world. I was a compliance officer, deputy general counsel, chief privacy officer. I dealt with our PAC, which is our political action committee, the lobbying. I dealt with the environmental, but that was about 4 levels below me, so I am not the 2 degrees versus the 4 degrees versus the Plasticine era. I'm not that level of environmental expert. There may not even be a Plasticine era, I don't even know, which shows you I'm not an expert in that area. But a number of issues dealt with our audit committee, our corporate governance, and I've sat on a number of state, federal, local, and international industry groups that deal with a number of CSR and other kinds of issues. So my context comes from a business focus, but also an academic focus. So that's kind of where I'm coming from. Here is my agenda, talk a little bit about the problem. And I'm not going to get into the shareholder primacy model, which I think is a huge problem because that's been discussed a lot, but I want to tell you from the US perspective another problem, which is this. This is a statement by a sitting US senator who has been in the Congress for 17 years. He wrote a book, which I probably should have read to be more informed, but I didn't think it was necessary after having read the quote. This was in response to a radio question, which misquoted the section of the Bible. And for those of you that don't choose to read the whole slide, because I know I shouldn't read a slide to you, basically saying human beings can't do anything about climate change because there is God. I do teach at a Catholic university. These views are my own. This does not reflect the view of St. Thomas. I'm not saying people at St. Thomas do or don't believe in climate change, since this is being on tape. But I'm just saying the US Senate has 100 people. The House of Representatives has 435 people. These are the people that almost destroyed the world economy a few weeks ago. And this is an important view, and he wrote this in 2012 in a book. He's also received $1.5 million from the oil and gas industry over the tenure of his career. That's relevant. I don't know how campaigns are done in the rest of the world. The presidential campaign for 2016 has already started, and that's relevant to my talk. So we all know what I've called the truth, which is what came out in 2013, in September. What are companies saying in the United States? So 700 companies have signed on to the Paris Climate Declaration. It might be a little bit more. This was as of the end of October. Cirrus now has a big truck that goes by in Times Square so that people can know its message. And they say, this is an exact quote, tackling climate change is one of America's greatest economic opportunities, and it's simply the right thing to do. And they have that in the parentheses to make it sound more folksy and colloquial. And they have investor assets of $12 trillion. But Celia has already gone through the fact that the SEC issue, and that only 27% of publicly traded companies have even mentioned climate change in their public filings recently. So what's our problem beyond the shareholder primacy model? We've got the Citizens United Supreme Court decision that allows corporations and unions to provide pretty much unlimited funding to political candidates, and these are the people that regulate them. There's a history of corporate involvement in shaping climate change science. So not to pick on only Exxon Mobil, but they were the biggest in the 90s, that although they could have survived the Kyoto Protocol, and there is evidence to this, and a carbon tax probably would not have significantly adversely affected them, spent a significant amount of corporate resources, it is alleged, and there are documentation of this effect, helping to fund science that, that changed the debate, both in Congress and with public perception. Exxon Mobil now, by the way, is the biggest natural gas producer in the United States. And yesterday, the New York Times reported that the 5 biggest oil companies and 20 other companies are disclosing that they are now building in carbon, some kind of amount in their financials about carbon tax. They're assuming it's coming. These are the same companies that, by the way, lobbied very hard against it. Companies think like businesses. They know it's going to happen. They have insured against it, which is what we've been talking about. The Supreme Court is deciding a case right now about whether the EPA, Environmental Protection Agency, has overstepped its bounds on regulating greenhouse gases. The Environmental Protection Agency under the Bush administration was sued by states saying, you're not regulating greenhouse gases. Now companies and other states are saying, you're regulating them too much. So now the Supreme Court, by 2014, will make a decision on this. And almost every regulation that the Environmental Protection Agency does is subject to challenge by people in the Congress or by the states, which have to then do their own implementing legislation. And then, of course, the Congress does also pay for the appropriations of the regulations. So Americans tend to believe in climate change depending on how they actually feel on that day. And this depends on how cold or hot the winter was, because it goes up by 5 or 10 percentage points depending on when the survey is taken. And so a Yale University study, this is what they say. So and this was done in April 2013. Yeah, there's global warming, 63%, but less than half think it's actually attributed to human behavior. This is not an accident. And these are the people that elect the Congress people that regulate the companies. So, but by the way, they want the government to do something about it. We don't know why it's happening, but government should do something. So, what can the government do? There's green public procurement. China has green public procurement. They call the Beijing Olympics the Green Olympics, but there's the green public procurement in China doesn't work out so well. The EU has it, UK has it, a lot of countries have it, and that's when you should use preferences or mandatory requirements when you're going to be a government contractor. The United States government is the largest procurer of goods and services in the world, $350 billion a year. Of course, not all of it is green. What do presidents do when they don't want to deal with Congress? They bypass Congress altogether, and they do executive orders. So President Obama did one actually on November 1st to prepare United States agencies and others on the 1-year anniversary of Hurricane Superstorm Sandy, which devastated the East Coast. But it's been done in the past repeatedly. Executive orders are subject to constitutional challenge and litigation, but it's a way to bypass them altogether. You tell the agencies, I want you to put in these kinds of regulations. It doesn't have to be just environmental. And so a number of the environmental regulations dealing with procurement have come from executive order, and that's another way that it can be done. So you've got the environmentally preferable purchasing program, which started back in 1997 when the FARs, or the Federal Acquisition Regulations, do have preferences. Department of Defense, by the way, pretty much makes this almost mandatory. Why, you say? They look at it in a number of ways. Department of Defense actually looks at climate change, they have said it publicly in speeches, as a national security issue and a world security issue. Their view is that if you have droughts in certain parts of the world, that could lead to unstable governments, and then they'll have to go and deal with that. Or if their troops can't get energy or water, it makes them unsafe. So they actually have a very interesting way that they look at it. There are a few exceptions when you don't have to comply with this for the Department of Defense and for others, but there are green procurement regulations. The problem is it's pretty hard to actually get off of the government procurement once you're a contractor. So one of my proposals is to make it easier for them to get you off the list. It's easier to suspend or debar you. So, revise the federal acquisition regulations to facilitate quicker suspension or debarment for failure to comply with the requisite standards during the term of the contracts, and contractors can and should agree to subterms in their contracts. Require the chief executive officer and chief financial officer to do a number of things. Again, this is for U.S. companies doing business with the U.S. government, as well as their subcontractors. It's completely voluntary. You don't have to do it, but a lot of companies want to do it. Similar to Sarbanes-Oxley, which requires a certification, have them sign a similar certification, an attestation of compliance, that we are complying not just with what we say we're going to do in terms of the environmentally preferable procurement program, but with the environmental laws to which they're subject. An audited, credible third party that provides no other services, so that you don't have the management capture that we talked about before, and that undergoes some kind of training and certification process, so that you don't have, no offense to any assurance providers or auditors, so I'm not going to name any of the big four, but that you don't have people that aren't trained in environmental auditing doing this. An additional incentive, if you elevate a responsible person to a high level within the organization that's focused on sustainability efforts, you can get additional award credits or additional preferences in being able to become a federal contractor, all other things being equal. And then finally, pay. DoddFrank Financial Reform Act requires clawbacks. Sarbanes-Oxley also has clawbacks, but it was based on different factors. Dodd-Frank requires clawbacks of certain incentive-based compensation for executives going back 3 years, regardless of misconduct or fault. A number of companies are adding in any number of other things that have nothing to do with what Dodd-Frank requires. So I say that those same 700 companies that have said climate change is the right thing to do, that have all of these greenwashing things, I'm not saying that's greenwashing, but if it was, then I think then you should go ahead and add in some kind of clawback, not just for your executives, but for members of your board, because what gets measured gets treasured. So if you say that you're going to do this, then you should be willing to take some incentive-based compensation or some board compensation, because then board members will ask the same questions that they ask about Foreign Corrupt Practices Act, export controls, and everything else that can land people in jail or land them on the front page of the Wall Street Journal. So if the company fails to live up to its contractual commitment or files false attestations as determined by the independent third-party auditor, then they're going to be subject to executive compensation clawbacks, and this will have to be put into the contracts with the government. If you don't want to do this, you can't do business with the federal government. What are the benefits? It's totally voluntary. You don't have to pass any kinds of laws with our Congress, which is a little dysfunctional at the moment. You can avoid litigation. You can avoid legislation. You leverage the purchasing power of the federal government and then get the state and local governments involved. And by the way, the state and local governments are doing better than the federal governments. There's regional consortiums in the Northeast, in California and Florida that are doing not something as tough as this, but that are already trying to get around in terms of their building standards, et cetera. There are public schools that are using sugarcane trays instead of other kinds of trays to be more sustainable. Flow it down to subcontractors to have more meaningful impacts. You impress your socially responsible investors. You avoid greenwashing, and then you hold the boards and executives more accountable, not just the companies, because often the companies are held accountable, but the executives and board members are not. Time to have questions.